Okay, you ready, Susan? All right, I'd like to call the meeting of the Tennessee Auctioneer Commission for February 2014 to order. If you would call the roll.
Bobby Colson,
Here.
Ronnie Collier, Gary Cunningham, Jeff Morris,
Here.
Howard Phillips.
Here.
Okay, we have a quorum. If you would, please read the notice of meeting.
This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website since January 27th, 2014. This meeting has also been noticed on tn.gov's website.
Okay, so the notice of meeting has been read, and we wanted to adopt the agenda for this meeting.
I'll make a motion we adopt the agenda.
It's been moved.
Second.
Seconded. All in favor say aye.
Aye.
Aye. If you would, please turn to tab 1 and look at the minutes from the last meeting. And you might want to review those for a second. And then we'll need to adopt those. Chair will entertain a motion to be accepted.
I'll make a motion we accept the meeting as read.
Second.
Moved and seconded. All in favor say aye.
Aye.
Aye. Rest of them are not here. Do we have any updates on the seminars and newsletters?
Yes, the next seminar will be May 19th at Montgomery Bell in Burns, Tennessee. And the following will be in October, and it will be in Kingsport, Tennessee. The location was not provided.
Julie, we'll turn it over to you to do the legal report. That's tab 2 on our handy-dandy laptops here.
I'm sorry, when I sent it out to y'all, it still had January because our January meeting hadn't been, I'd already had it prepared and then we got canceled. So I fixed it on my copy, but and I'll have it fixed for the minutes, but everything else is the same, so. The first matter on the complaint, on the legal report is 2013
Give me the two.
Oh, I'm sorry.
All right.
Y'all ready? Okay, 2013-015-681. Complainant submitted one of respondents, that's a firm, advertisements for a consignment auction. Said advertisement states that respondent is holding a consignment auction of farm equipment along with items such as lawn mowers, RTVs, tractors, skid steers, trucks, and cars. Respondent does not have a public automobile auction license. Complainant states that it is not permissible to sell vehicles on consignment. The complaint was opened and sent out for a response, and an investigation was opened to determine more information regarding this auction. The investigator was referred to respondent's attorney to gather the information requested, who informed the investigator that the attorney would prepare an affidavit including the requested information and supply all pertinent information promptly. The attorney wrote a letter stating that the only motor vehicles auctioned were associated with the auction of heavy construction equipment and were exempt pursuant to Tennessee Code Annotated Section 5517-120, which was incidental to the sale of farm equipment, and non-qualifying motor vehicles were pulled from the auction after being contacted by TAC, as it was not respondent's intention to violate tax laws or rules. There was also an affidavit from respondent's president, which included licensing information with TAC and the Motor Vehicle Commission for respondent and the individuals involved on the subject auction sale. In the subject auction sale. The affidavit admits that neither respondent nor any of the individuals calling the auction hold public automobile auctioneer license to the best of respondent's president's knowledge. Further, the affidavit referenced an attachment of items sold by each individual participating in the subject auction. Finally, the affidavit stated that a public automobile auction was not conducted and stated that any motor vehicle sold met exemptions found within Tennessee Code Annotated Section 5517-120, subsection B or C. Respondent's advertisement stated that respondent would auction individuals such as trucks and cars at the subject auction. Based on a review of the item list for items sold at the subject auction provided by respondent, it appears that there were 2 items sold at the subject auction which do not meet any of the licensing exemptions found at Tennessee Code Annotated Section 5517-120, namely 2 motorcycles. The recommendation is to authorize a formal hearing with authorization to settle by a consent order with a civil penalty for $1,500 for violations of Tennessee Code Annotated anticipated sections 6219-102A3 license requirement and 6219-128 licensure of public automobile auctions. Okay.
Howard, you got any questions about this?
And if I was advised upstairs that I double checked it with the chief counsels that we do have a quorum, and even with one recusing member, they thought that a majority of the quorum was okay to go ahead and resolve this. If y'all'd like to defer this till the end of the meeting to see if Commissioner Cunningham shows up, we can do that. Or, like I said, they've advised that that they believe it's okay for the two remaining members of the quorum to vote if you all are in agreement. So that's up to you.
Did this sale take place?
When did the sale take place? Let me grab my. It appears it took place in August of 2013. Yes, August of 2013.
They agreed to pay the $1,500 fine.
No,
would be
this
a
is
consent
presented to
order.
you all first, and then a consent order is sent to them if that's what you all accept. At that point, they have the opportunity to either accept that consent order or the matter goes forward to a formal hearing.
Agree to it or fight it and come up here and plead their case?
They, but the investigator went out and investigated everything and found that the only two items they were selling that fell under the public auction license was 2 motorcycles.
The investigator provided me with a listing, and I reviewed it with the attorney for the Motor Vehicle Commission just because I wanted to understand that exemptions within their laws that they're claiming, and I reviewed through it with him, and those were the only two that we found that were not in
Or any
compliance.
pickup trucks or Jeeps or,
Not that I saw. It was a somewhat lengthy listing, and both he and I went through it, and those were the two that had jumped out at
Everything
us.
else was heavy equipment
It appeared to be to me.
or
and
farm equipment?
It appeared to be to me, and like I said, I reviewed it with him because, I'm not exactly.
but in the ad, they stated they had trucks to sell.
Exactly. They advertised it as such.
So I don't know that you would advertise that you had trucks to sell that you didn't have.
Well, they stated that they pulled their non-compliant vehicles. That's what their attorney
They
stated.
intended to
But it
sell 'em, but they
appears that
didn't
they
sell
might
'em.
have missed two based on my review of it and my review with the Motor Vehicle Commission's attorney. So
They pulled all the trucks, they just didn't pull the motorcycles out.
that appeared to be to us. And like I said, I had someone assisting me with it because I'm by no means an automobile expert, but he helped me with it.
They pulled the other items after the inspector went and we got
Oh,
called.
I guess,
After they got the complaint is what the attorney states.
well, somebody filed a complaint, they pulled them, and they didn't pull the motorcycles.
I'll make a motion that we take legal's recommendation for a $1,500 fine and
I guess I can second that.
a letter of instructions about a public automobile auction. There is a lot of confusion.
Want the consent order or the letter? I have to close it. I can't. I've got to do it by one or the other. The consent order would contain the facts and the pertinent law in it, because it states out, here are the facts, here are the provisions of law that, it is.
Consent order with a civil penalty of $1,500.
Okay.
It's been moved, it's been seconded, we're both in agreement.
Aye.
Aye. Then we're gonna, so we move to item number 2, we'll wait on Bobby, just take a 2-minute break here.
Okay.
I agree, there's a lot of confusion out there about what you can and cannot sell in terms of vehicles are concerned, and it's,
And I'll just tell y'all, I guess I can tell them that I'm not going to be doing the legislative update as it states in there. There's a lady named Greer Kelly, and she works in the commissioner's office. Is that correct? She's part of the legislative team. She's the one that's going to be giving the legislative updates for all of the commissions. So you may see her come in, and then she'll be giving the legislative update for this and all the other ones. It's not just you all.
Okay.
So
We'll be cognizant of her time if she comes in, and we'll.
I think she was going to the Cosmo meeting first, so she should be over shortly. So.
Off the record, let me ask you a question about this case. Who's getting this?
The complaint was opened against the company,
Firm.
actually, the firm is who it was opened against.
Who's the auctioneer?
Yeah, wish I thought quicker.
Olson,
Yes.
we're waiting on you.
He cares as usual.
Start charging him for extra cups. Okay, we're back in session.
We're going to continue with item number 2 on the legal report. It's 2013016601. Complaint opened by TAC based on respondent's auction advertisement submitted to TAC's office, which includes respondent's firm license number but does not include respondent's firm name as licensed with TAC. Respondent submitted no response to the complaint, although the complaint was signed for at respondent's address on file with the commission. After the complaint was opened and a copy of the complaint sent to respondent, it appears that the owner, principal auctioneer of this respondent, which is a firm, applied for and obtained a license for the name which was utilized on the subject advertisement. The recommendation is to authorize a formal hearing with authorization to settle by consent order with a civil penalty of $500 for violation of Tennessee Code Annotated Section 6219-112B7 and Rules 0160-01-.05 subsection 1 and 0160-01-.20 subsection 1 regarding advertising and auction sale.
You're telling me that he advertised as under one name and he actually is licensed as another name?
Basically, what it was the advertisement had the license number as required by our rule, but the firm name was not the same as the license that went as the firm name that went with that license number. At that time, there was no firm licensed under the name that was being used. After the complaint was opened and a response was sent out, this person got a second license for the name that was being utilized in the advertisement, but still the license number wouldn't match up. There's now 2 firms. It was one license number and a name that did not match that license number.
Were the names totally different?
There's a first part of the name and a second part of the name. It's a DBA, and the whole part was included, and neither part was identical. There was a name referenced in one part, which is the same, but neither part was identical. The firm number was on there, like I said, but the name as, registered with that license was not the same.
Firm number was correct.
The firm number was correct.
I mean, was it like Joe Jones Auction Company, and then one of them just said Jones Auction Company rather than Joe Jones Auction Company?
I'll give you, okay. The DBA, both of the first part of the name is an LLC. That part, totally different. No similarity except the LLC, but the DBA was also included. And the DBA, I'll use your name for example, would be like Bobby Colson Auctions versus Colson Auctions. So there was a similarity in the DBA, but not in the first part of the.
First part was totally different.
The first part was totally different, other than the fact that they were both LLCs. But the entire name, including the DBA, was in there, if that gives you a better idea. I know that's difficult when it's anonymous, so that's why I'm using your name as opposed to anybody else's. So there was a similarity in that last name was the same, but that was the only similarity. I hope I didn't get into too much.
Probably a fair fine. Get that straight.
But they went and applied for a license after.
Yes, I did check that on the licenses.
And never did respond and just filed for a license afterward.
And
Okay, yeah, I'd probably.
Yes. this is not one of those situations where it could have been a mistake.
I'm not sure. One would think that if it had been a mistake, they would have responded and told us that. And there was, considering there's a history here too, which sometimes I don't think that necessarily puts into play. But when you're looking at someone that doesn't respond and clearly
Well,
is
they didn't.
familiar with
That's
the
what
complaint
gets me. They
process.
didn't-
They didn't
They didn't
respond.
respond, but they filed for, then applied for a license under that other name, so.
And I would assume this person's familiar with it as the license has been held quite a long time. It's not a new licensee that maybe wouldn't be familiar, just thinking, oh, I'll go fix it and it'll be okay. I don't know. You all may wish to change it to a letter. It was just a variety of factors considered.
Since they didn't respond, I'll second the motion. Did you make a motion?
No, you need to make a
I did.
You did make a motion?
I did.
Oh, it's been
Yeah.
made and seconded. All in favor say aye.
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 Number 3, 2013-018-211. Complainant had personal items which were sold on consignment with respondent, a firm, in September 2012. Complainant states that complainant called multiple times over the past year requesting information about when complainant's money would be received. Complainant was told by one of respondent's representatives that the computer crashed, but was repeatedly assured that the money would be sent soon. As of the filing of the complaint in September 2013, complainant stated complainant had not received the money. A response was submitted on behalf of respondent stating that complainant's merchandise was sold at auction on September 2012, and approximately 1 week later, respondent's computer crashed. The response states that the data had not been backed up, which resulted in an inability to retrieve the records to make payment until recently. The response states, and a copy is included, that a check was sent to complainant along with a consignor settlement statement on the same date that the response was sent to the commission. The recommendation is a letter of warning regarding Tennessee Code Annotated Section 6219-112B4, requirement for timely accounting for or remitting money belonging to others.
Personally, the computer crashing has nothing to do with not paying people for the merchandise that they brought to your auction and sold. That is absolutely one thing that my pet peeve. You need to pay the people a week after they sell it or as soon as possible. This is no excuse.
You want me to look up the
It's
civil
almost-
penalty range for that
Yeah,
violation?
because it was almost a year later.
It was, and I understand that. I mean,
That's
I
just-
didn't.
I agree with Howard. I just-
Okay, the range for a violation of B4 is $0 to $1,000. That's the range in your rule for that failure to timely account, which is the citation that I have included in
Took them
here.
a year to pay the people.
About a year.
I make a motion that we give him a penalty of $500.
Consent order with a $500
yes, ma'am.
for a violation of the citation there. Okay.
For not paying the consigners.
Okay.
Second.
It's been moved and seconded. All in favor say aye.
Aye.
Aye. Motion passes.
4 and 5, 2013-018-331, 2013-019-471. These complaints involve the same piece of property which was offered for auction. Respondent 1 was a company located in another state which was unlicensed until October 8, 2013. Respondent 2 is a licensed firm located in Tennessee. A complaint was first opened by TAC against Respondent 1 due to an anonymous phone call. The individual informed staff that Respondent, then unlicensed, was advertising a real estate auction in Tennessee. Information was located online by staff that indicated Respondent was conducting a live auction of the property in Tennessee. A complaint was opened and an investigation requested regarding this matter. The investigator contacted the listing broker for the property, who stated that Respondent 2, a licensed firm, was now going to conduct the auction sale, but that Respondent 1 had originally planned to conduct the sale. The investigator also spoke with Respondent 2's principal auctioneer, who stated that Respondent 2 had an auction contract with the property owners and Respondent was hired as a marketing company. The investigator received a copy of this contract. The investigator visited the auction site on the original planned day, but discovered that no auction was to take place that day and had been delayed. Then the investigator spoke with Respondent 1's president to request a copy of the marketing contract and original sale agreement between Respondent 1 and the property owners, but received no information. The investigator then contacted the property owners, who verified that Respondent 1 was the original choice for the marketing and sale of the property, and the property owner provided a copy of the original contract which provided that Respondent 1 would market and sell the property by public or private sale. When visiting the auction site on the second scheduled day, the investigator spoke personally with the property owner, who informed the investigator that the auction had been canceled and the property was being kept with the original listing agent to sell through traditional means. Respondent 1 submitted a response through an attorney stating that it's the attorney's understanding that by obtaining licensure through TAC in October 2013, the issue had been resolved. Further, the attorney states that the subject property was not listed by Respondent 1, but Respondent 1 was hired to conduct the auction online and market the property, but the property owners had the property listed with a licensee with a real estate firm in Tennessee. The attorney states that Respondent 1's role was to advertise the property on the internet. A complaint was opened against Respondent 2 regarding its online advertisement from Respondent 2's webpage, which was provided to TAC for the subject property. Said advertisement states that there is no reserve, but includes a starting bid price. Additionally, the advertisement for the auction does not appear to include Respondent 2's firm number. Respondent 2 submitted a response stating that the firm number is at the bottom of the main page of the website, and the submitted page for the complaint was the 5th page into the site, and the firm number was at the bottom of the page. Respondent 2 submitted copies of the website pages. Further, with regard to stating that the auction is absolute but including a starting bid price, Respondent 2 states that this is not misleading or deceiving the public because a dollar amount has to be put in on the website for the online bidding. Further, Respondent 2 states it is clearly specified that there is no reserve and that any bidder must place a refundable deposit in Respondent 2's escrow account to bid on the property. The recommendation is to, with regard to Respondent 1, send a letter of warning regarding Tennessee Code Annotated Section 62-19-102 license requirements with regard to Respondent 2 dismiss.
They're playing their typical games is what they're doing on this.
It seems to me like we got caught. Please forgive us. And I don't agree with a company from out of state that doesn't have a real estate license that they don't find out what the law in Tennessee is before they advertise an auction. And why would this be just dismissed?
Well, the dismissal is regarding the second one, the advertising issue.
But he advertised an auction, absolute auction with a reserve.
It just had a starting bid price.
But that's
the
a
same thing.
reserve.
He said that an amount had to be put in, and it did not mean that necessarily somebody had to bid that price. It's just there had to be a field filled in there.
Dollar in there.
Well, it's still.
And I think he argued even if a dollar was in there, it could still be misconstrued. It could be construed as misleading too if there was no reserve. So that was his.
If you check our law about an absolute auction, it tells you that you can't have subject to a $600,000 note.
An absolute auction or an auction without reserve is an auction at which property put up for sale is sold to the highest bidder, where the seller may not withdraw the property from auction after the auctioneer calls for bids unless no bid is made in a reasonable time, where the seller may not bid himself or through an agent, and where the seller would deliver marketable title. That's the definition in the rule.
Every auctioneer knows that you cannot have a starting bid price on an absolute auction.
Absolute above a certain price. So that's like being a little bit pregnant.
That's
It
exactly
just-
right.
it just-
Yeah, you can't do that.
Well, I'm not happy with dismissing this.
All the facts in this case. Somebody was hiring this first auction company to have an auction sale, and then when they were told not to have the auction sale, then they went ahead and hired another auctioneer to do that one, knowing that they weren't licensed in this state.
This is the way
Am I reading it wrong?
The second one came in later, it appeared, based on the documents that the investigator obtained, which was the reason why the investigation was requested, because it seemed we were getting different stories when I was trying to.
See if I'm correct. a company in somewhere out of state books an auction in a real estate auction in the state of Tennessee, and advertises an absolute auction, and somebody realizes that they don't have a license and they get caught. So then they change and go hire somebody else to do the sale for them. Is that correct?
The first person, I don't believe there was any there was no problems. I think it was advertised as an absolute auction, but no starting bid issues with the
Understand
first
that.
person.
But
Yeah.
it was an out-of-state, non-licensed company advertising an absolute auction in the state of Tennessee.
To do a live sale on site, right?
Yes, that's what it appeared from the advertisements.
In my opinion, this is where the huge problem lies.
They still don't have a license in this state, right?
No, the first respondent that was previously unlicensed did obtain a license on 10/8/13. You'll see I have it highlighted there. That was after the complaint was opened, but the sale did not take place through them, and they did obtain.
Now they come under our rules,
What website are they talking about that a dollar amount has to be put on?
their own.
That's kind of what I'm thinking.
Auctions, and they don't have starting bids. for
Auction
their
Zip
auction.
advertising doesn't have one, an online auction. So, the best deal here, you can put it on, but you don't have to put no price on that.
See, our MLS, you do have to put a price
I
on.
well, I take it back. I don't know what you do or not here. You might,
Yeah.
but you can put $1.
Yeah.
We do
Yeah.
online auctions almost every
I've
week,
never put one on
absolutely.
MLS
We have
line.
no starting bids.
I've
on
never
it.
put one on the MLS line, so I don't know.
MLS, we put it up there and said that's just an indication of value only. It's not a bid.
That's where it had been changed to one, it looks like. I know, but I'm not sure that that's the subject one that was the complaint. When it was submitted with the complaint, it looks like it's on the firm's
The
actual
firm's website,
license.
that's
And
what I
then later
said.
with the response, when the individual that's the principal auctioneer submitted the response, stated that it would be just as misleading to have, whether we have $1 or a higher amount, it is deceiving either way. No one is, going to buy a house for $1, but they could potentially buy it for the price they have. But it looks like from a copy that they submitted later on, they changed the starting bid to $1. It does have no reserve in parentheses right next to the starting bid. In both
Well,
instances.
that helps.
In both instances.
That helps.
And it's all over saying, no reserve.
It says a starting bid of $500, no reserve.
It says a starting bid, and it has an amount in there which is larger than $1, and in parentheses right next to it, it says no reserve.
Now,
We know if it's sold or not.
we're all more than fifth graders. Would any of us understand that we got to start something for X number of dollars, but it's no reserve? I make a motion that we give both respondents of, what do you call that?
Consent order.
Consent order of $1,500 each.
Okay, we've got to have,
Got to be within the
we've got to
range.
have it, we've got to state the law, and it's got to be within the ranges of that.
People selling that real estate unlicensed.
6219-102, which is the one regarding the first person. A1 says it's unlawful to act or advertise or represent to be an auctioneer, apprentice auctioneer, or firm without holding a valid license under this chapter or prior state law. The range for A1 within your rule is $0 to $1,000. 6219-102, A2, conduct or offer to conduct an auction of real property unless the person is duly licensed as an auctioneer or apprentice auctioneer and as a broker or affiliate broker under the Broker Act, is a separate one. And A2 has a penalty range of $0 to $1,000 under your rule.
Maximum would be 1,000, however.
So,
So you're saying it's 1,000 for each one?
It's a
where-
that,
for
your
the
rule,
out-of-state advertising an auction would be $1,000.
acting as or advertising to represent to be an auctioneer or firm without holding a license has $0 to $1,000 range within your rule. And then 2, which talks about conducting or offering to conduct an auction of real property without being licensed as an auctioneer or apprentice and as a broker or affiliate broker, is a separate subsection, and it also has a range in your rule of $0 to
So
$1,000.
he's guilty of both those, right? He offered to do an auction, which is without a license in state, and that's $1,000. And then he advertised an auction without a license, and that's $1,000. Is that correct?
It was an advertisement of real property.
Carries a $1,000 penalty for advertising it without a license.
It says conducting or offering to conduct, so if you interpret an advertisement as offering to conduct or entering into an auction contract, then yes, that would appear to be the case here.
So actually, he would be subject to up to a $2,000.
Under these ranges, under your law, it does have 2 separate ranges for each subsection within the same statute.
750 times 2, that would give you your $1,500.
Do that.
That's just for one we're talking about right now.
Respondent 1, right?
Yes,
Okay. Respondent 1, 1,500 for violation of 62-19-102, A1 and A2.
750 times 2.
Okay.
Bobby, you want a second?
I will second that.
Bobby has seconded that. Are you clear on that one?
I've got it. Now,
Okay.
can we do,
All in favor?
Aye.
and now with respondent 2, the advertising issue.
Well,
Do-
he's fuzzy on that one, so I don't,
I guess, if you're saying you think that it would be confusing to the public, then your statute that would address that, might fall under 62-19-112. There's making any substantial misrepresentation. It might fall under the advertising rule. Your advertising rule. Under 0160-01.20, which is the advertising guidelines, it states in subsection 2, false, deceptive, misleading, and untruthful advertising is expressly prohibited. Any advertisement or advertising shall be deemed to be false, deceptive, misleading, or untruthful if it A is a misrepresentation of fact, B is misleading or deceptive because in the content or context in which it is presented makes only a partial disclosure of relevant facts, creates a false or unjustified expectation of the services to be performed, contains any representation or claim that the advertising licensee in bad faith fails to perform. E is a lengthy one, but talks about advertising using descriptive words such as emergency, urgent, distress, which wouldn't really apply here. F, advertises an auction using descriptive words such as seized, confiscated, or forfeited, not really here. Or G, advertises in bad faith an item for sale that the auctioneer, auction firm, or gallery does not intend to offer for sale at the auction being advertised.
we don't have any violation for advertising an absolute auction that's not an absolute auction.
Within that rule, it does address absolute auctions in subsection 3, but it talks about when some items will be auctioned with reserve and some are without reserve. It talks about the font size. You all are familiar with that. That's come up before. You could say, you basically stated you thought it was misleading to the public, so it could fall under false, deceptive, misleading, and untruthful advertising based on what it sounds like you just said to me. You thought it was confusing to, misleading or deceptive because in the content or context in which it is presented, it makes only a partial disclosure of relevant facts. If you all believe that's there, or misrepresentation of fact, or false or unjustified expectation of the services to be performed.
I was here when we wrote the law about an absolute auction, and it most definitely, there is a penalty for advertising an auction with a reserve, absolute auction with a reserve, without it fell through the cracks somewhere.
Well,
But I make a motion that we give respondent two $1,000 consent order.
and that would be for a violation of the advertising rule? Yes. And then would you like me to also include the rule with the definitions of absolute auction and an auction with reserve? Because there's no civil penalty range for the rules, but that would be tacked in under 6219-112B7, which is violating any provision of this chapter or any rule or regulation promulgated under this chapter. That is $0 to $1,000 for B7.
Been moved and seconded. Do we do a consent order of $1,000 for violation of the rule? All in favor say aye. Aye. Motion passes. What I'd like to do is stop right here and skip to the legislative update, since we have the representative in the room here that's going to do that for us, and she's busy, so come on up and introduce yourself.
I very much appreciate that.
Just talk into the microphone.
Perfect. Good morning. I'm so glad to be here with you today. My name is Greer Kelly. I am a new legislative liaison with the Department of Commerce and Insurance. I have been here 2 months and 2 days, so still pretty green, but very excited. You all do not have, I came to give you a legislative report on the bills filed that would affect you. Thus far in the 108th session, there's no legislation affecting auctioneers. And you do not have a sunset hearing this year. So that's all correct. Make sure we
Get
have,
it right, Greer.
we track about 300 or so bills so far.
Right.
So I don't want to tell you the wrong thing. So not much to report today, but I would be happy to come back whenever you all meet again, and I am going to leave several business cards so that if anything comes up that you're concerned about, or if the bill filing deadline is Wednesday, February the 5th, so if any bills are filed between now and Wednesday that affect you all, that I can keep you in the loop.
Hey, we appreciate that very much.
Thank
Howard?
you.
Is there a bill in a committee where the state of Tennessee must sell, I guess it's their excess merchandise, like the trucks?
Concerns real estate, that they can't.
Okay.
Are you familiar with that?
I'd have to get back to you on that. It sounds kind of familiar.
1623, Senate Bill 1623, I think.
Okay.
I haven't seen it, and typically something like that would be assigned to me, but that doesn't necessarily mean it's not there. I had no knowledge of it. Usually I have to do analysis of anything affecting my boards, and it has not come to me, so.
Well, I would like, if there is such a bill, that somebody would kind of look after the auctioneers, because
Okay.
if it's going to be sold, my opinion is that it should be sold by a Tennessee licensed auctioneer.
Put that on your radar screen, Greer. We'd appreciate it very much. We appreciate your
Absolutely.
update.
Absolutely. We'll always have your best interest. You all have a good board meeting. Very nice to meet you.
Thank you.
Thank you.
Now let's jump back to our legal report, and we're on item number 6, Julie.
Okay. 2013018.
Can I please stop?
Sure.
I didn't get through before.
Oh, I'm sorry.
Would you please check on an absolute auction and see if Bobby can advertise that he's going to sell this building over here at absolute auction, and he can advertise it that way with a reserve,
Or minimum opening bid.
minimum opening bid,
Mhm.
or subject to a bank note?
All I really
Or
have is.
absolute above a certain number. I mean, those are all ways people try to get around the absolute portion of it.
and here's-
quite honestly, it really goes back to the UCC, where the definition, where we've adopted the UCC for us, and it's more particularly spelled out in that.
And subsection 2 of the auctions defined is an auction with reserve. You know, it states an auction at which the seller or his agent reserves the right to establish a minimum bid, to accept or reject any and all bids, and to withdraw the property at any time prior to the completion of the sale by auctioneer. So conversely, I think you could take that to mean that one without reserve means there's no minimum bid.
Right.
By your own
Well,
definitions. That's why including that rule in the consent order, I think would be instructive, because those are the definitions we have here in the rules. And like I said, when you have a reserve, when it says an auction with reserve, that talks about a minimum bid, saying you can have a minimum bid for this type. And if you're saying absolute, then that would be the difference there. So that's why I asked you.
Every
all if you wanted to
auctioneer
include-
tries to dance around that.
That's why I asked if
it's-
you wanted to
it's gotta
include
be as
the
clear-cut as-
advertising and this one in
It
there.
has to be as clear cut as possible as far as this commission is concerned, because I agree with Howard. You know, we see every language nuance there is to try to dance around that, no reserve.
I'll include that rule as well as the advertising rule in there, since that's what you all indicated you wanted to be
Right.
spelled out in there.
Okay.
And I think that combining the two definitions, that, clarifies it more. So, are you ready for me to move on to
Howard,
number?
does that satisfy you?
Yes, ma'am.
Okay.
Are you
now
ready
I-
for
We
me-
just, we need some teeth in it if we don't have it.
Well, I think two helps to describe that, with reserve, you can have a minimum bid, and that's the difference in the two in your rule that you have.
Right.
Number 6, 2013018941, complainant alleges that respondent firm advertised a machinery consignment auction on AuctionZip and Craigslist, and complainant copied the text of the advertisements into the online complaint. Complainant states that the Craigslist advertisement only contains 2 telephone numbers and no names. Complainant states that AuctionZip ad contained as contacts the names of 3 individuals and telephone numbers, but no firm name or number on either advertisement. 2 of the individuals who are listed as contacts appear to be unlicensed. The third appears to be a licensee who is the owner and principal auctioneer of Respondent, which is a firm. The owner principal auctioneer of Respondent firm submitted a response stating that Respondent held the auction referenced in the advertisements, and the owner principal auctioneer acted as auctioneer. Respondent's owner principal auctioneer states that the other 2 individuals whose names and numbers were on the advertisements were only organizers for the auction, and those individuals did not act as auctioneers. Respondent's owner principal auctioneer states that the original flyer was corrected to show Respondent's firm and auctioneer license number long before the auction was held, and attached a copy of the flyer including the license numbers. The flyer includes the name and license number of the principal auctioneer as well as Respondent's firm license number, but does not appear to include Respondent's name as required by the advertising rule. The recommendation is to authorize a formal hearing with authorization to settle by consent order with a civil penalty of $500 for violation of Tennessee Code Annotated Section 6219-112B7 and Rule 0160-01-.20 subsection 1 regarding advertising and auction sale.
So the first flyer that came out didn't have it, and then all the other flyers did have it. And did he correct all of it well before the auction sale? I mean, do we know the dates of any of these things?
The complaint was not very good because I couldn't locate the ads that were referenced, and they were just copy and pasted into an online complaint form, so I'm not sure about those.
All right.
The response, his response was sent in. It appears that the complaint was filed after it took place, and but the advertisement that was submitted had, like I said, the principal auctioneer's name and license number, and the firm license number. This is open against the firm, but does not have the firm name on there at all. The firm name is omitted, which is what.
On the first advertisement?
This is on the one that was submitted with the
Okay.
response.
But everything
saying-
else that you saw had it, right?
No, the ones in the complaint didn't have
Okay.
either, but I wasn't able to confirm those because they came from Craigslist, and I think by the time that it had gotten opened up and everything, I couldn't locate it, and it was copy pasted. It wasn't
Craigslist
copies.
advertisements shaky at best, anyway.
So I'm not sure they were copied pasted in there. I don't really know about those. I just know that even with the response saying, "Hey, here's my compliant advertisement," the firm name was omitted from it. The license number was on there. I'm sorry, these are so hard to present anonymously, especially with the advertising ones.
Right, right. ahead and make a motion.
Go with legal's recommendation.
Second.
Moved and seconded to accept the recommendation of the legal department. All in favor say aye.
Aye.
Aye. Motion passes. Item number 7.
2013020511, complainant alleges that respondent, auctioneer, held a consignment sale of complainant's personal items, mostly household items, according to complainant. Complainant and respondent signed a consignment form on June 6, 2013, for the sale of household contents. Complainant states that respondent promised an itemized statement of items sold and payment for those items. Complainant states that complainant spoke with respondent once and there were some items left to be sold. Since that time, complainant states that complainant has been unable to reach respondent and has not received payment from respondent. A copy of complaint was sent to respondent at the business address and home address on file with the commission. Both were returned unclaimed and no response was submitted. In the previous complaint against respondent indicated that respondent was back in another state and respondent's firm was closed. An internet search did not reveal any information indicating that respondent is conducting auctions in Tennessee at this time. You'll see in the history there's one that you all authorized previously for a formal hearing. The recommendation is to authorize a formal hearing with authorization to settle by consent order for voluntary surrender of respondent's auctioneer license for violations of Tennessee Code annotated Section 6219-112B4 regarding timely accounting for or remitting money belonging to others, and subsection 12, conduct that demonstrates improper, fraudulent, or dishonest dealings.
Can the state open a criminal fraud charge against people like this?
I think our, to the best of my knowledge, our understanding would be just referring it to a district attorney would be what we could do.
I got you.
I don't know that our group can pursue them.
I mean, this just flies in the face of
Right.
consumer protection.
And, we could also refer it to Consumer Affairs along with this, maybe they can work something out, but they are bound by their mediation process, and this person doesn't appear to be cooperative. I don't know that that would yield any
Right.
resolution for this person. I should have introduced her. I guess she had other business. You might have all seen a lady sitting over there. Robin Ryan's taking over the litigation for this. It's my understanding that this person is the next one that she's scheduled for a hearing before you all, and she's going to try to schedule that as soon as possible. But
Does this person have a Tennessee auctioneer license?
they do have a license. The expiration date is later this year. But like I said, I could find nothing online indicating, any advertised auctions. I couldn't find much information based on the previous complaint. All of both of the subjects' sales took place in the summer of 2013. It's not been any recent activity. All appeared to be around the same time.
Right.
And that's why I included that information there stating that this person claims they're back in another state. I don't know that. I mean, that would be something that, we would have to see about in trying to.
Well, you want to make a motion?
What do you have to do to flag his auctioneer license where that they can't be renewed until he settles this?
I don't think that we can do that, but I think that we can probably have this hearing before the renewal date. She's talking of having this hearing in later spring, early summer, so. If he does not agree to the consent order, which there's been a consent order in the past that was not agreed to, so I would.
Consent orders for him to turn his license in.
If he agrees to it, then it would be a surrender of the license.
Surrender, that's what we're saying. He has to give up his license.
That would be the offer in the consent order,
Right.
so.
But when you have a consent order, he has to show up.
The consent order is an offer to settle the matter. After that, it's turned over to the litigation attorney and formal charges are authorized. They have to come to the formal hearing at that point. A consent order is something they can sign and send me back by mail, but like I said, in the past when that hasn't been done, I would not
Been done.
imagine that's going to be done here.
Nothing to make you
No
think he's gonna do it
guarantees,
now.
but
Right.
I don't know. Based on my past
I would just
experience.
accept the
Yeah, okay with me to go with legal's recommendation.
Is that a form of a motion?
Yes, it is.
It's been moved.
Already got them set for one anyway, or working on one.
Second.
Been moved and seconded. All in favor say aye.
Aye.
Aye. Item number 8, if there is an item number 8.
I'm sorry. Okay, number 8, 2013022691. Complainant states that respondent, affirm, conducted an auction for complainant and respondent failed to conduct the auction pursuant to the terms and conditions set forth in the contract. Complainant does not specify what respondent did that was in conflict with the contract, but states that complainant raised repeated concerns throughout the auction as to how the auction was being conducted and the results it was bringing. Further, complainant states that complainant instructed respondent on 5 different occasions to stop the auction and put no more items up for sale, but states that this was ignored by respondent's representatives. Complainant states that because of respondent's actions, complainant suffered large monetary damages. Complainant further alleges that respondent has not provided an accounting of all monies received by respondent on complainant's behalf, and respondent has not submitted the collected funds to complainant. Respondent submitted a response stating that complainant entered into an exclusive absolute auction contract and provided a copy, with respondent to liquidate complainant's business at absolute auction. Respondent states that the auction was held as scheduled but was stopped with at least 2/3 of the inventory remaining due to complainant's behavior toward staff and bidders alike. Respondent states that pursuant to Auctioneer Commission Rule 0160-01-.19, which in part defines an absolute auction, respondent does not believe complainant had cause to stop the auction event, but respondent felt that complainant's behavior resulted in cancellation being the only choice. On the following morning, respondent states that complainant demanded a meeting with a complete accounting of the auction and a check for the auction proceeds, and complainant stated that complainant would not release any merchandise to any bidder until complainant had been paid in full, although complainant had previously allowed buyers 3 days to load merchandise. Respondent states that respondent agreed to give complainant a full accounting of the auction but could not settle with complainant until buyers had been given a receipt of their merchandise and the buyers had purchased the merchandise at sale, expecting to have 3 days to pick it up, so there was a possibility for financial implications resulting from that. Respondent provided the total amount of sale proceeds, the amount deducted from escrow as of the date of the complaint due to refunds and stopped payments as a result of complainant's actions, and an amount of the buyer's goods which are still in possession of the complainant. Respondent states that the case is in litigation and complainant's attorney has been provided an accounting. Complainant submitted a reply disputing the statements within the response, stating that respondent has swindled complainant out of merchandise worth a large amount of money and respondent has commingled complainant's auction funds, and that a full and/or accurate accounting of the funds has not been provided. The parties are currently engaged in active litigation relating to the subject auction. Based on the fact that the matter is currently in litigation, it is likely that more information will be uncovered through the course of the civil litigation which could be pertinent to the Commission's determination of this matter. The recommendation is a consent order for litigation monitoring.
I do agree with the legal department. We do need to see what comes out of this case so that we'll know how to act. A whole lot of finger pointing going on there.
Sometimes they have powers that we don't have to,
That's
subpoena
true.
documents and things like that. And we believe we've done this once before, later or mid to late last year, where it was in litigation.
Right.
And that's something that's been relatively new in the legal department, where instead of closing pending the outcome of litigation, we send out this litigation monitoring consent order, which basically says the commission has not made a determination against you, but there's the civil litigation ongoing, and you're agreeing to keep us updating, notifying us as soon as it's over, giving us documents when we request it, and keeping us abreast of what's going on.
Fine with that. I did notice in the beginning of this that there was an absolute auction contract signed.
It was an absolute auction contract.
Okay.
Mm-hmm.
All right.
A copy of it was provided, and it stated that it was to be absolute.
I move that we accept recommendation.
Seconded. All in favor say aye.
Aye.
Aye. Motion passes. Item 9.
92013022741. Anonymous complainant states that respondent, an individual with an expired auctioneer license, is unlicensed and is calling bids at auctions. Complainant references two auctions, one of which allegedly took place in Tennessee. There was no documentation included with the complaint. Complainant states that complainant personally knows respondent and wishes to remain anonymous for that reason, but complainant's reason for filing the complaint is for the purpose of protecting the public from an unlicensed person who is bid calling. Respondent states that respondent did not know that respondent's license had expired until respondent received the complaint. Respondent states that this was an oversight and would like the opportunity to make things right. Respondent states that respondent has been in the auction business for 45 years and respondent has been mostly clerking with very little microphone time. Respondent states that respondent wants to do the right thing as respondent has respect for the commission and the profession. Respondent states that this was a mistake and respondent will make it right if given a chance. As of the date of legal counsel's review of this complaint, January 24, 2014, respondent is still expired. I checked this morning before coming into the meeting, and as of today's date, February 3rd, the license is still expired. The recommendation is to authorize a formal hearing with authorization to settle by a consent order with a civil penalty of $1,000 for violation of Tennessee Code Annotated Section 6219-102A1 license requirements.
How long has his license been expired?
The expiration date was July 31st, 2009.
Got 9?
2009.
That's important.
And that's in your materials. I have it highlighted in yellow.
I see that now.
And I did check it again this morning to make sure, because in the response it indicated that this person wanted to make it right, but as of as late as this morning, I checked.
So he has to start all over
I
again.
believe if making this right is he's got to go back to apprentice school
He
for 2
does,
years and serve an apprentice for 2 years and then go for his.
And that would be
auctioneer.
something if he decides to, yeah.
And it wasn't a deal where they had to get to continuing education because they would have been exempt. All they had to do was pay their money.
Yeah. Yep.
And I didn't see any notes.
Chair will hear a motion.
I make a motion, we go with legal's recommendation, which I think is kind of sparsely, but I'll go.
Been moved,
Second.
seconded. All in favor say aye.
Aye.
Aye. Item 10. Is there a 10?
We only have 9. That's
Only have
all I
9.
have, actually.
All right, well,
so-
good deal.
Bet you're happy.
Well, that was all the files I had for now, so there'll be more coming, I'm sure, but. And I believe that's all I had, since she took care of the legislation update, so.
All right.
Oh, I'm sorry, I'm so sorry, Kimberly. I did want to give you all a copy of, the rules that we had discussed. They're still in the approval process. I'm trying to, get them moved through as quickly as possible, but we'll get it set for a rulemaking hearing as soon as. I wanted to give you all a copy, and these are not to be disseminated to anybody else
Right.
until we publish them. They're still attorney-client, so I'm giving them to you all. But
Okay.
I wanted to point you to the military applicant rule and just make you aware that I was, after we had discussed these and you all had said, let's proceed with them at the last meeting, it was pointed out to me that within the military applicant rule, that legislation that required that also required, for the possibility of issuing a temporary permit for the people that meet the requirements for that military applicant rule. And I had to add in a subsection for that, which is at the bottom of page 5. I was advised by Chief Counsel that this was required by the legislation, and it's been put in all of them. I wanted to make you aware of it. He said that there was no further action needed from you all. It didn't really change the scope of your analysis of what you did.
We talked about that for a minute.
You did talk about the rule. I had to add in a subsection, and I just wanted to make you aware that when we got to the rulemaking hearing, if it was in there, I don't need anything from you all. I just wanted to make you aware that it had been added in and was going to be in there when it went forward, so. And I think I needed to update you on one other thing. Somebody had asked for an update on the matter that's in Chancery Court at a past meeting.
Yes.
I spoke with Adrian Chick, who's still kind of handling this. This has been going on since before I got here, so he
Right.
kind of updated me. Basically, there's been no change. It's still in Chancery Court right now, and they're waiting on a ruling on the cross petitions. So I'll keep you updated on that. But I did check in with him shortly before the meeting, and he said no change, and he would keep me posted. And likewise, I'll pass that information along to you all. And that is all I have. I'm sorry, Kimberly.
Why don't we skip down to the apprentice auctioneer application?
Certainly. This is on tab 5.
Tab 5, okay.
I have a short little summary if you'd like.
That'd be great.
The following apprentice auctioneer applicant resides in Rock Island, Tennessee, which is in Warren County. She is requesting a waiver from the commission pursuant to Rule 0160-01-.125. All sponsoring auctioneers shall reside in the same state as his or her apprentice auctioneers. However, in appropriate cases upon good cause being shown, the commission may waive this rule. The auctioneer she would like to sponsor her resides in Scottsville, Kentucky. The first page for our application is a letter detailing her request. And Ms. Morrow is also present today.
Why don't you have her come forward and kind of explain what's going on so we can understand what's. Morning, Stephanie.
Good morning. How are y'all?
We're good.
Should we
Kind of just give us a thumbnail sketch of what you're doing and what you want to accomplish and why you're here today.
Well, actually, I wasn't born into the auction business, but while I was getting an accounting degree at Middle Tennessee State University, the small auction there in town, ABC Murfreesboro at the time, which is now Dealers Auto Auction, I worked there the entire time while I was getting my degree, and just basically fell in love with the business. Just couldn't. I graduated and didn't want to be sitting in a room pushing paperwork. I wanted to be
Right.
out there with people.
Right.
So I ended up staying in the auction business, and then somehow it's evolved into, I just started ringing a little bit, and then they said, hey, why don't you go to auctioneering school? And I said, I think I might just do that. So, and then I've just fell in love with it ever since. And basically, as far as Russell goes, as I've been in the business, I also own a car dealership in McMinnville. And as far as Russell goes, I've just known so many people in auctioneers, and I really wanted to think hard. I didn't, and rather than going out and saying, hey, will you sponsor me if I go to auctioneering school? And them say yes, and then thinking I would never go, I waited till I finished. And then thought really long and hard, because there are, from sitting here and hearing all those complaints, there are a lot of auctioneers out there that don't conduct business right. But the auctioneer that, or was I supposed to remain anonymous? Was I not supposed to say his name? Okay, I was about to say, everything else was anonymous here, I'm sorry.
Oh, that's just for the legal report.
Okay, I was about to say, he's a preacher, he's just a great guy, and he's the most, where cars are always gonna be where my passion lies. I wanna be a wholesale car bid caller as far as that goes, but I was also blessed enough to go to school with Wendell Hanson, and he said, don't sell yourself short, definitely get as much experience as possible. And Russell's got his hand in everything. He's got his own car auction up there. He's booked through April, I know, every single Saturday. And he does what I do, which is, I'm ringing right now at a couple auctions, and he works those as well. So
You live here and he lives in Kentucky.
he does.
and
It's about an hour, and I can get there from about an hour and a half from here. But we work the same auctions right now, because most of the ones that he does are actually in Nashville, Murfreesboro, and around
How do we get, if we do this, how does he attest to her experience requirements and all that? Can we do that?
How many miles is it from your house to his company?
I believe it's something around, don't quote me, but around 80. Like I said, it takes about an hour
From
and a half.
McMinnville to Scottsville.
Well, from where I drive, I'm used to driving constantly,
Yeah.
so that's, it's, like I said, I can make it in about an hour and a half. I'm not sure.
I
of
used
the
to buy
mileage.
cars in Scottsville all the time for
Did you?
very years.
Does he do most of his auctions in Tennessee or Kentucky?
Well, he has, his real estate auctions are in Kentucky, all of those are, but as far as his wholesale, he has three automobile auctions he does every single week here in Tennessee, in Middle Tennessee.
He calls he's a bid caller at automobile auctions in Tennessee.
Yes, sir, ones that I'm already employed at as well.
And he has a public automobile auction in Kentucky.
Yes, sir. Which the ones I'm working right now are just wholesale.
You have a
They're
Tennessee
dealer.
license?
Yes, he does have a certificate.
He has a Tennessee license, but he resides in Kentucky. Is where,
Yes,
Okay.
and
A
he has a
reciprocal
Kentucky
license.
license.
I got you.
Did you try to find somebody that's qualified in the state of Tennessee as this guy?
I did, and as far as
Be careful.
Well, there's several. I'm sure they're just as great a person as he is and as great as auctioneers. But as far as personalities and knowing somebody and trusting somebody with the start of my career for the next 2 years, I feel more comfortable with him than I do anybody else.
I'll be honest with you, I have a problem living an hour and a half away from somebody that you're gonna be working with, and he has, basically his company is in Kentucky, and he sells at 3 car auctions here in Tennessee, which, there's people from all over the United state's calling these car auctions.
But he has a Tennessee license.
I understand.
Yeah.
As he calls that, they only, I mean, he calls in Clarksville a lot too, in Tennessee.
Are you gonna be working out of his office?
Am I gonna be working solely out of his office? No, sir.
Are you planning on going into real estate too, or?
I said, but basically my passion lies with automobiles. Wholesale automobiles is what I want to focus on. But like I said, I want to get as much. I don't want to sell myself short. So if I was to get same thing as getting the accounting degree and getting involved in the auction business and falling in love with it. If I was to be involved in a lot of his realty and get interested in it, who knows? I might change my mind. I'm young. I've got a lot of options.
That's your apprentice license, right? That's what you went to school to get, okay? That,
Have a sponsoring auctioneer.
right. But how have you got it planned out to get all your hours in the clerking and doing things at his auction?
I mean, I plan on going to his auctions as much as possible. Like I said, he's booked up every Saturday through April. I plan on attending every single one of those without any problems. And then we're also already, like I said, already employed at some of the same wholesale automobile auctions now. So I'm just waiting on the license to be able to get up there behind the mic.
Driving 80 miles to an auction?
No, sir. I've been in the car business for years, and actually as soon as I leave here, I'm headed to Alabama, Fort Payne, then back to Nashville, then back home. So I'm used to being in a car, unfortunately. Traveling doesn't bother me a bit. Like I said, I'm young. I'm pretty open.
I move that we give her a variance and let her get her apprentice under
It's been moved.
Mr.
You want to make a second?
Mills. It'll take you a while.
Go ahead, I'm sorry.
I said it's gonna take you a while, but you know.
I second that. I'll second it, and we'll vote on it. I mean, I don't have a problem with it myself, but I know Howard does.
Yeah, I mean, it's gonna be a long road to hoe, but she's willing to do it. More power to her.
Been moved and second. All in favor say aye. Aye.
No.
All opposed say no.
No.
No. Motion passes 2-1. All right,
I don't
Stephanie.
believe you'll do it, okay?
I'm sorry?
It's not, I don't believe you'll do it. You'll do a good job. You're determined. But you're putting yourself in a lot of strain.
I understand.
Good
But
luck.
if it makes you rest easier, if I would have chose somebody in Tennessee, they would have been further away. That's my backup, so. They would have been further away. He's just right over the state's line, so.
How about it?
I appreciate
Good luck,
it.
Stephanie.
Y'all have a good day.
Y'all good? You want to keep going? You need a break?
What time is it?
It's 10:15. All right, let's move on to the complaint comparison report.
Yes, sir, that information is on tab 3.
Tab 3. All right. I wish we could get rid of that one. We did get rid of that one? No, I guess it's still in it. 22, 32.
Right in that, tied to that litigation.
Right.
You'll see that last year at this time you had a total of 61 complaints. Currently we have 50. The 180-day performance measure is at 97.92%. So it's
Okay.
very, very good.
Yeah.
Divisional
And
standard
of the
is
50, how many are tied up with that one case?
The 22.
22? Is it the 22?
No, it's more than that. There were 9 pending, and Julie just presented all of those.
Uh-huh.
So I think there's 37 in Chancery. There's
So 9 of the 50 are the 9 we just considered now.
So
Okay.
we don't have anything that's
We don't
just
have
laying out
anything
there.
hanging out
And
there.
one more. And there's one that
So
has
that's
just,
40
that's not made it to
40.
me yet.
Okay,
So-
and then we got the formal hearing. How many just that one formal hearing that you know that's coming?
Well, that would involve 3 different matters.
Right.
And then I think there's 2 other matters that are in litigation as well. And then I believe the rest are tied up.
Okay. All right, well, good deal. You know, we're just trying to stay on top of this stuff, you know, get it as it comes in. And we're not too far behind, so I think the commission's doing well on that. You want to talk about the budget report now?
Certainly, on tab 4,
Tab.
One to try to hunt where the tab.
I know. Okay,
the first page shows the revenue year-to-date, well, actually through 11/30 of 13. We received some updated information on Friday, but this was as of Friday. This is the 11/30. You can see
13, okay.
the revenue. And the next page shows your expenditures, and the expenditures are actually through December. So there's a little,
Okay, so we got, that's not apples to apples.
correct.
Okay.
We'll make sure next month that we have, that we
Is
keep
there
them.
anything that we should be aware of that this report points out that we need to be cognizant of?
No, sir. You had asked last month regarding the number of licensees,
Right?
and we are still seeing a little bit of a slip as far as the number of people. Currently, you have 1,699 auctioneers, 1,054 firms, 37 public auto auctioneers, 13 auto auctioneers, which is auctions, I'm sorry, I'm sorry, and a total active licensee count of 2,803.
That's down from what? Do you know?
It's a loss of 55 from, so a little 29, almost 29 as of,
Not falling real rapid.
no.
I'd like to see it.
Again, just, we continue to see that, just a slippage in the number of people renewing.
How many did we lose to deceased? Do we ever have a count of that?
We can certainly pull that information
I
for
was
you.
just curious. I figured that, you know, now that we've had the law around a while, I know we've lost some. And we hear about them in our business. Okay. There's nothing we need to act on as far as this report is concerned, correct?
No, sir, this is just for information purposes only.
Okay. And then auction regrouping, review, discuss, email inquiry, tab 6. Is that the next item?
Yes, sir.
Tab 6. All right.
I just turned the page and
Yeah,
said my
I
oldest
did
daughter
too. That's-
said that her mother was 17 years old at the time I visited me at home, and involved in an activity with another school friends, which I did not approve of when I attempted.
You assaulted me and I defended myself. It's good stuff. It's good
I
reading.
don't think that's y'all's.
Wait a minute.
I'm sorry, yes, I would be also curious.
I had me
It's
something
good
more for a
reading, isn't it,
minute.
Howard?
Yeah, boy.
That's not my stuff.
It's good reading.
Yes,
isn't it,
it's
Howard?
page 3
I
of
put that
the
in there,
financial
Nick.
report.
Yes, this is
Liven it up a little
this is
bit.
not attached.
Julie just did that to see if we were paying attention. That's what.
These weren't so glamorous that I presented you with.
Something was scanned.
That's
Yep,
funny.
yep, yep.
My apologies.
That's
That's
all right.
funny.
That's all right.
That was actually.
I thought it was maybe a script for a Lifetime movie of the week or something. I didn't know.
Where we go?
Tab 6.
Okay, tab 6. The following is an email inquiry received through the commission's email. And it is requesting an opinion regarding regrouping of items during an auction. And the staff, we felt like we needed your input and opinion in order to properly respond to this inquiry. And it's on the next page, and it starts with "Hello, Commissioner."
I don't know that we have a rule regarding whether you can group or regroup.
I didn't see anything, because Kimberly and I talked about it, and
Right.
I did not see a problem, but not being in the industry, I was the one that thought maybe, it would be maybe I was missing something.
Oh, that's typically up to the auctioneer.
From reading this, it seems like somebody got some misinformation somewhere.
Right.
You are trained when you start out. That you are working for the seller, and you're supposed to do everything that you can do to get more money out of the merchandise that you're selling for the seller. And this may include grouping or regrouping items. Correct?
Yeah, what you also are trained to do, that you don't hammer it sold. You say, you post that bid and then you break it up or put it back together. Usually, and goes back to a UCC thing again as well, once the hammer is cried sold, it's sold. And that's just.
Suck it back in?
Huh?
You can't suck it back in?
Nope.
I think somebody just got some misinformation there. It says that it's no longer going to be legal in the state. Well, I hadn't heard anything. You ain't got anything in those new rules about that, do you?
No.
I didn't,
No.
it seemed like a situation I'd never had been questioned about before, and that's why I thought, we had a meeting coming up, it'd be best to ask people that had actually done
I would
this
just respond back that we know of no rule or law that covers the
We don't know of
grouping or
anything that's gonna be
regrouping
changed.
in a auction sale, and it's typically up to the auctioneer acting on behalf of the seller.
There is occasions when you sell it both ways.
Right.
You can sell the whole pile and write down what it brings.
Right.
And then you can split it up and sell it, and whichever way it brings more, that's the way it goes. But you
have to let the audience
you
know
let the
that.
audience know.
Exactly.
Thank you, I just wasn't positive and didn't want to give the wrong information if you all felt differently.
Yes, we reached out to the person making the inquiry and advised them that we would consult the commission at their next meeting and
But-
pass the information along.
Okay, we're done with that item. Is there any unfinished or new business to come before this commission? Not, I will entertain a motion to adjourn.
I make a motion to adjourn.
I'll
Moved and seconded, motion passes, we are adjourned. See y'all in March.